Hello everyone, my name is Michael Turner. I work at Waterstone Insolvency. I'm here with my colleague William Robinson, who you already know. Today we'll be having a high-level discussion about security interests. Security interest is like tax in that it's a simple idea with a lot of little rules and exceptions. A good way to think about security interests is by way of analogy. Today we'll be using the motor vehicle loan as an analogy. It's generally known that if you take out a loan to buy a car and you don't pay, the finance company can take the car back and sell it in consideration of the loan.
Security interests are like breathing. It's something that a lot of people know about, despite not understanding the intricate details.
The key elements to security agreements are as follows: understanding a security interest and a security agreement, the personal property securities register, and the ranking of security interests, where there are multiple in one specific asset. Security agreements generally. A security interest, is a legal right granted by a debtor in collateral, for example, a motor vehicle. Collateral is pledged to secure the obligations of a loan or other form of agreement. The four most prominent examples are a car loan, a business loan, a retention of title clause, and lastly, a mortgage.
Your typical hire purchase or motor vehicle loan is a secured motor vehicle being pledged as collateral. In this case, the debtor is the individual taking out the loan, the creditor is the bank or financier advancing funds to buy the motor vehicle, and the collateral is the motor vehicle. In the event that the debtor defaults on the loan, the finance company or the creditor will have the right and ability to repossess the motor vehicle and sell it and apply the proceeds from the sale to the loan.
Moving on to general security agreements. The cornerstone of most New Zealand business loans is the General Security Agreement. A General Security Agreement, or GSA, grants the creditor or lender an interest in all present and after acquired personal property of the company, and among other entitlements, the ability to appoint a receiver over the company. A general security agreement means that in the event of default, the bank will have the right to sell essentially everything not subject to another first-ranking security interest, and other specific examples, for example, debtors and inventory, where staff and the IRD are owed money. The agreements are structured as followed. The debtor is the business/company. The creditor is the bank or financial institution. The collateral is all present and after acquired personal property of the company. The agreement is the business loan. Another example of a GSA we've seen in application is the landlord of a company obtaining a GSA over their tenant to secure rent in the case of a commercial lease.
Moving on to retention of title clause. Colloquially known as the Remalfa clause, the retention of title clause are typically found when suppliers supply goods to a customer before the customer pays in full. Simplified, a retention of title clause means that the goods supplied will remain owned by the supplier until they are paid in full despite being delivered to the customer. For example, if a building company goes into liquidation, Bunnings Warehouse can come pick up their timber provided they have adequate security documents. Have you ever heard of the phrase Remalfa clause? The most famous example of a retention clause is the Remalfa aluminium case. In 1976, an aluminium company delivered to Remalfa aluminium on credit. Before delivering the aluminium, the company got Remalfa to sign an agreement saying that the aluminium in question would remain property of their company before Remalfa had paid in full. Sadly, this would not be for Remalfa as he was placed into receivership. The receivers were in possession of £50,000 worth of aluminium, £35,000 as well being the proceeds of the sale of Remalfa's aluminium. It was ultimately determined that the aluminium company owned the aluminium and were entitled to the identifiable proceeds of the sale, being £35,000.
And the aluminium itself.
Notably, it was ruled that this clause trumped the General Security Agreement. Thus began the Remalfa or retention of title clause.
In this case, the debtor is the customer ordering goods on credit, so for example the builder. The creditor is the supplier of goods, in this example Bunnings. The collateral is the goods supplied, for example, timber. Moving on to mortgages. A mortgage is an agreement which grants a security interest in land to fulfill the obligations of a loan. The most prominent example of this is your standard home loan.
Thinking of what we've learned, let's see what possible issues can arise. What if a company in liquidation has both a car loan and a business loan with a general security agreement? Who sells the car?
This is where the two key ideas of the PPSA, or the Personal Property Securities Act, comes into play. The idea of attachment of a security interest and the perfection of a security interest.
The attachment of a security interest has three key elements. The security agreement, i.e. the car loan, the debtor must have rights over the assets, and the creditor must provide value to the debtor. Value from the creditor to the debtor can take many forms, but it usually consists of funds advance or goods supplies to the debtor. As mentioned earlier, we have also seen the provision of rent secured via a GSA. This also ticks the value test.
Moving on to perfection of a security interest. Perfection of a security interest has two key elements. Firstly, attachment, just previously discussed. And secondly, that either A, a financing statement is registered on the PPSR, or the secured party has already taken possession of the collateral, except where possession is the result of seizure or repossession. Taking a step back, the Personal Property Security Register is an online notice board where secured creditors can register their interest in personal property. You can search companies, individuals, or specific collateral. For example, motor vehicles, provided you have the Rego, VIN, or ideally both, to determine whether other lenders have a security interest in any assets of a prospective debtor. The PPSR also allows you to lodge a financing statement against debtors to register your interest in assets, which is essential for perfection. Coming back to our example, priority, generally speaking, has three main rules to consider. A perfected security interest defeats an unperfected security interest. So coming back to our example, if the bank has a financing statement registered in respect of their GSA, and the finance company for the car loan does not, then the car can be sold and that debt will go, the proceeds from the sale of the car will go towards the GSA holder. Taking a step back, if there are two perfected security interests, the party which registers their financing statement on the PPSR first, or takes possession of the collateral, but not through seizure or repossession, will have priority. Now, a slight caveat to that. Generally speaking, there are timing issues with a financing statement being registered. So if you have attachment of a security interest, you're allowed a grace period, depending on the specific type of asset, which we won't get into right now. Lastly, in the event of two unperfected security interests, the party which attaches first will have priority. Thank you for having a watch. If you've got any questions, feel free to ask.